So you can all go go behind the blinds if you want to at this point. I can't, unfortunately, but anyway, there we go. All right, so this is LAWS 12066, land law, and today we're looking at topic 4, which is covering unregistered interests in Torrens land and priorities. Now, just as a little bit of an overview, Monets are to be encouraged, as are other great artists. Just to give a bit of an overview, you will remember, of course, that we dealt with the priorities topic in Foundations, LAWS 12065. That was in the area of general interests, general property interests, particularly in land. Now, given the fact that in Queensland, of course, all land is actually Torrens title land, there's no general law land, that discussion is a little bit, I suppose arguably to some extent from a practical point of view, a little bit opaque, but we do need to go through it because the rules that govern priorities between competing interests in land under the general law are still important and help to inform our understanding of the priorities issues with respect to competing interests over Torrens land governed by the Land Title Act 1994 in Queensland. So what I would say to you, just by way of brief sort of suggestion, is to go back to that topic in Foundations and have a bit of a look back through there, because there are several of the cases there that are mentioned in this topic, and in particular that more recent AGC case, 2010, I think, Queensland, which also refers to some of the earlier case law, is quite important, and I've also incorporated that into the notes for this topic 4 in land law. This is a challenging area, people, and if you've had a chance to work your way through the material, through the framework of the material, the case law, some of the cases are quite challenging. The factual matrices are quite challenging. What people seem to get up to and what they're prepared to do with regard to interests in land and documents of title are quite interesting. And how we resolve these issues of competition, given the fact that the Land Title Act provides the system for the recognition of an interest through registration and upon registration and by registration pursuant to Bresvar and Wall, as we know. But the idea of how we deal with unregistered interests and how we deal with equities and equitable interests continues. Equities, of course, recognised under the LTA, in other jurisdictions, not through a specific provision of the LTA, but through the recognition afforded through the case law, Fraser and Walker, and subsequent decisions there. The other big idea that comes in this topic, of course, and is referred to, where do we start discussing it? On page 13 of the notes, in terms of the competition between unregistered interests, and that is the process of caveating under the Land Title Act and the provisions that deal with caveating there. And one of the very contentious points, and this comes out, and deliberately so, in the problems for today, that is, what is the role of the caveat? What should be the role of the caveat? How has it been interpreted by the case law? And the truth is, we have a continuing debate about this, and we have some strong views in the case law, and I'm hoping that you can bring out a bit of your views today about what should be the role of the caveat and how we should tackle that and approach that. In terms of the unregistered interests, whether it's critical, whether it's determinative, whether it's just one part of the armoury that a person who doesn't have a registered interest can actually utilise, where it fits within the scheme. Again, we need to remember that the provisions under the LTA and the wording of the sections under the LTA and that framework, not only with respect to caveats, but in other provisions that we touch upon in the course of our discussions today, are not identical to the provisions in other jurisdictions. And very often the case law that we're looking at has come from those other jurisdictions or from disputes out of those other jurisdictions. So we need to be mindful of that when we're applying the case law, but we do need to apply the case law against the matrix that's provided for us in this sense under the LTA with regard to Torrens provisions and how we deal with the disputes between competing interests in that context. Well, just lastly, before we proceed, good. Just the types of priorities, of course, that we are contemplating in this topic, as you can see there on page 3 of the notes, between 2 registered interests, which is not terribly complicated, it's just a question of timing issue there. Registered interests and subsequent unregistered interests, unregistered and then a subsequent registered interest, 2 unregistered interests, and of course the knotty problem of the prior equity and the subsequent unregistered interest. And as I said, it's a challenging area with a body of complicated case law and legislative provisions, but there is a way forward and a way to navigate our way through the terrain. So let's have a go. All right, we'll proceed then to the first of our questions at hand, which is problem 7. What is the distinction between just case and Abigail? Is it possible to reconcile Butler and Fairclough with just case? Who'd like to launch off on this? And if you want to start just by giving us a bit of a factual overview of a couple of these cases or one of these cases, that's fine. We can proceed from there. Okay.
Okay, I'll have a go at the facts of the case. I think I put an answer up there for this one. But the Lapins were husband and wife, the registered proprietors, and they both executed a transfer in favour of their solicitor. I think it was Heavener or someone. As security for costs and a payment.
Can I just stop you there, Lisa? Heavener was actually the transferee. Okay, the solicitor was Abigail.
Oh, okay, thank you. So they effectively gave the solicitor authority to deal with the property, but not for their own benefit. And then transfers were lodged in breach of the authority, and Abigail then misused that authority. But in the end, the Lapins were bound by their negligent actions because they armed the solicitor.
Can I just stop you there?
With the certificate.
Sorry, just to stop you there. What was it? What was the document that was that the Lapins had actually given to allow this to deal with this security issue? What was it that they gave to the solicitor?
Oh, it was a memorandum of transfer.
Was it filled in any particular way?
Was that where they had left it blank? So I've read so many cases lately. Was that the one where it left blank?
We just we go back. I'll just go back to the facts just to clarify just a little bit. But you're going well, Lisa, and I want you to continue. So basically, we've got the Lapins, Mark and Pearl, who are husband and wife. They were plaintiffs in the action, and the Lapins executed 2 memoranda of transfer, not 1 but 2, and they were with respect to 2 properties, in respect of which they were registered proprietors in estate in fee simple of each. So we had the Lapins. There were 2 memoranda of transfer with regard to 2 lots. If we were in Queensland, we'd call them lots or parcels of land that they respectively owned. And they basically filled out a transfer, and this was used as the basis of getting some security over these properties. But, you know, they had given this these memorandum of transfer completed as far as possible to the solicitor. And then what happened then?
He misused his authority. So.
How did he do that?
He mortgaged the property.
Yes. Anyone else want to come in at this point? Aisha, any thoughts?
Yes, I do have a few thoughts, but whether they're correct or not, I'm not sure.
We'll see. Just chance your hand.
All I understood from that case, and I did not read it, I only scanned parts of it, was that their carelessness allowed the fraudulent behaviour to occur, and by that it deemed that their interest was postponed, so they ended up having a second in time interest, whereas the Lapins had a first in time interest.
Yes, I'm just wondering, I mean, why did they give these transfers completed to Abigail for the purposes of security? I mean, why would they do that?
I thought it was for security for costs. So was it for security for legal costs?
Yeah, but why would you? I mean, doesn't it seem a bit odd that you'd give an executed? Sorry, who's that?
Sorry, that was Lisa. I think it is really odd that you hand across your certificate of title as security for legal costs.
It wasn't even no, we're not even talking about a CT. We're talking about a memorandum of transfer. This is the document that transfers an interest in the property or in the lot to the transferee. If it gets registered, then the transferee becomes the RP. And are we saying that in this case that the Lapins gave Abigail this transfer document merely for the purposes of security with respect to borrowing some money? Seems a bit risky, doesn't it?
Yeah, it seems really odd. But didn't they also hand it across something to do with money that had to be paid to a bank?
Yeah,
as well. Wasn't there a second reason that they?
There was a mortgage to also to be discharged or to be paid out, if you like. One of the things that you need to be conscious of when you're reading these cases is that, and of course, the Abigail and Lapin. It's always important to have a look at when the case was decided. So, what year was Abigail and Lapin decided?
That was 1934.
Right, right. Now, it's not. I'm not focusing just so much on the year, but always in law, it is useful to have an historical context. Okay, and in property law, particularly in regard to land, and in regard to what we're doing, interest in land and dealing with interest in land and the effect of interest in land, which is what we're looking at here in this course. You cannot get away from the fact, I mean, we're not, this course is not about conveyancing or about the conveyancing transaction. I do another course that some of you are taking with me that we do that, but you can't get away from the fact that the process for facilitating the land, the interest in land and the transfer of the interest in land and how land law impacts upon that is actually a conveyancing process, and that there are land law instruments recognised under legislation that are critical to that process, and the transfer document is the absolutely critical document that transfers the interest from a seller or a vendor to a purchaser or a buyer. But the point that I'm getting to is that conveyancing practice changes over time and given circumstances, right? So that back in the 1930s, what was done here was not actually an uncommon practice. Why? Because it took it took time for things to happen, and the processes and the procedures and the administration was much slower than it is today. Certainly in 1934, there was no such thing as electronic transactions or internet or e-transactions or instantaneous transfer of documents from one place to another. None of that occurred. So different techniques were adopted at different times to facilitate processes. As we saw back in foundations, you might recall that originally the idea of the transfer of an interest with regard to land was this idea of season, and there was some special ceremony for that to happen. And then over time, lawyers found a way to not necessarily have to have that public ceremony, but there was a documentary process to make things easier and a bit more private and to speed the process up. So that's what's going on here in a different historical epoch. We're finding that solicitors, conveyancers, legal practitioners are doing things in different ways, and clients are a part of this as well, of course, to speed up the process when they want to do things. And mostly what they want to do is they either want to transfer their interest from themselves to someone else, or they want to get access to money for various reasons. And they then are using whatever assets they have, land, and the security mechanism of the mortgage, which we'll see in a couple of weeks' time, to facilitate getting access to those funds to do whatever it is they need to do. That idea hasn't changed, of course. People need to get access to funds today just like they have, back in the 1930s. But how they do that has slightly been adjusted, and the various methods and techniques to facilitate that, given the circumstances of the times and the way technology was and the way documents happened and so on and so forth, that's partly what explains what seems to us to be unusual in this case. Having said that, of course, I think there are certainly some issues with the way that the Lapins conducted themselves in then suggesting at the end of the day that their interests should, not be displaced, even though these transfer documents had been handed across, with Heavener as the transferee, which would allow Heavener to go out into the world and say, well, look, I'm the transferee, and once registered, I'm the RP. Right? But we do need to understand and this doesn't always come out in your materials or even in the cases, the issues about the practice. Another thing that comes up just as we move along is the idea of not registering a mortgage. Now, you might think today, well, goodness me, of course you register your mortgage. But there was a period where banks actually, and financial providers, mostly at the time historically we were talking about banks, they did not register mortgages. they just kept them, even though they certainly had the right to register them. And that was a practice at the time. So these things just have to be acknowledged a bit and understood as we proceed. All right. So we've got this conflict between the Lapins and the representatives of Abigail, because by the time this case came before the High Court, Abigail had actually died, sadly. Abigail, again, was a solicitor, so we're involved in another issue of the way the solicitor is working, but not necessarily. I mean, someone said earlier that Abigail had been fraudulent. I don't think that's how the court painted Abigail in the end, in this case. But they were certainly scrutinising the behaviour of the Lapins. What did the court say about the behaviour of the Lapins and how they conducted themselves? Someone who hasn't spoken yet. There are two people who haven't spoken. Luke, what do you think? Any contribution?
Scouring the notes for a contribution, Michael.
Do you think the Lapins have they embarked on what is arguably risky behaviour?
I believe the word that was used was careless.
What word would you use, Aisha?
Possibly a little bit silly, because they could have provided another document. So instead of a blank signed transfer, possibly they could have provided something else.
Yeah. So, and then in the end, so they had these transfers completed, even to the extent of having Heavener's name as transferee on the transfer documents. They left them with the solicitor for the purposes of getting access to funding and getting security. What were they then subsequently trying to argue after the interest had actually been registered and Heavener became the RP?
I thought they were trying to argue that there was an element of fraud which induced them or influenced them into signing the transfer.
Because if they could successfully argue that, what would they be able to succeed in?
Well, they'd get their fee simple back.
Because what would happen to Heavener's indefeasible title?
Well, it would be defeasible.
Precisely. But what did the court say in scrutinising the late, and I emphasise the late, Abigail? Did the court take the view that Abigail had committed some fraud?
No, not Abigail.
No, indeed. In fact, I think they were, the court was quite impressed by the way in which Abigail had conducted himself in these matters. And that argument was not successful. And the truth of the matter was that even though clearly the Lapin's interest came before the Heavener's interest, what had transpired meant that she was the RP now, and that had been registered. And the Lapins really should have been more prudent in the way that they'd conducted themselves. why is this point about the distinction between Abigail and just case? Because there's something else that comes up in the Abigail case that is a critical point that comes up in the just case. What's that?
Is it something about postponing behaviour that can take into account acts or omissions that a party undertakes?
Yeah, that's you, Aisha. Yeah, absolutely. Postponing behaviour. And primarily which party or which interest are we focusing on, or which individual, which party in the process are we focusing on in terms of the behaviour or the conduct for purposes of postponement?
I'm not sure.
Is it the earlier interest, Michael?
It is, Luke. Very well done. So we're looking at the earlier interest to see whether their interest should be postponed to the later interest, because the normal general law rule is first in time, of course, rice and rice, first in time, okay? But that's only if we are looking at a situation where the interests are equivalent, okay? But there's another thing that comes up in the just case, because in the just case, we've got the decision of Barwick, of course. And what's being focused on in the just case by Barwick?
Sorry, I just about lost my mic then. That case was different because the bank had actually held on to the certificate of title even though they hadn't lodged a caveat. So their interest wasn't postponed. That's right. But the point that you've just raised at the end of what you just mentioned is really the critical aspect, and that is that firstly, the postponing issue and how do we understand that and what do we look at to work out the postponement of an interest or of a claim. But secondly, it's this idea and the role of the caveat, okay? Now, what did Barwick say in Just's case about the caveat and how we understand how the caveat works under the Torrens system, under the Torrens Act?
Michael, I'll jump in there, Michael, and say Barwick said in the case that the purpose of the caveat acts as an injunction for the registrar to prevent the registration of the transfer, the property dealing.
Yes. Is that the same view that was taken by Griffiths, Chief Justice Griffiths in Butler and Fairclough?
The note that I've got for Butler and Fairclough is that it was the failure on the part of the prior equitable interest to lodge the caveat, which was enough to postpone the interest to the subsequent interest.
Yes, but what does Griffiths say about the purpose of the caveat? Purpose and aim of the caveat under the Torrens legislation.
Do you mean that it's protective?
What does he say?
Michael, if I've been able to find it here, he's saying that a prior holder who does not lodge a caveat generally has not taken adequate steps to protect his or her interest where he or she fails to take possession of a duplicate certificate.
Yes, that's right. Doesn't he also say that it acts as notice to all the world? Doesn't he mention that point? So, sorry, someone? Who is it? Luke?
That was my recollection of the readings that yes, that he.
I've just you've broken up a bit there, Luke, but I think you're saying yes. He does. There's a reference to Butler and Fairclough in the decision of Abigail and Lapin, because the Butler and Fairclough decision is even earlier still than the Abigail and Lapin decision. It goes back to one of the very early cases of the court back in 1917, and yes, that's right. We were dealing with equitable rights in relation to this type of land, and he says, for example, in dealing with such equitable rights, the courts in general act upon principles which are applicable to equitable interests in land which are not subject to the Act. So Griffiths is saying that we should really take the same approach to equitable interests under land that's governed by the Torrens statute as opposed to general law land. But then he goes on to talk about, and the quotation that's in Abigail and Lapin from Griffith in Butler and Fairclough, and approvingly endorsed in Abigail's case. Under the Australian system, a clear title on the register is, for some purposes at any rate, equivalent to the possession of the title deeds. A person who has an equitable charge upon the land may protect it by lodging a caveat, which in my opinion operates as notice to all the world that the registered proprietor's title is subject to the equitable interest alleged in the caveat. And when we come across to Just's case, Barwick says, the purpose of the caveat is not to give notice to the world or to persons who may consider dealing with the registered proprietor of the caveator's estate or interest, though if noted on the certificate of title, it may operate to give such notice. What's Barwick suggesting then? That the caveat, what is the role here of the caveat?
He's saying that the role of the caveat prevents the registered owner either not recognising equitable interests.
Yeah, but how critical is the caveating process in the protections that the non-registered interest holder has in terms of protecting their interest at the end of the day?
My understanding of that, Michael, is that it's not necessary for that equitable interest to caveat.
Exactly. Barwick actually goes on a little bit later in his judgment to say, to hold that a failure by a person entitled to an equitable estate or interest in land, and he's looking at a case in Just's case coming out of New South Wales, so he's talking about the Real Property Act, to lodge a caveat against dealings with the land must necessarily involve the loss of priority which the time of creation of the equitable interest would otherwise give, is not merely, in my opinion, unwarranted by general principles or by any statutory provision, but would, in my opinion, be subversive of the well-recognised ability of parties to create or to maintain equitable interests in such lands. So he's not disagreeing, I don't think, with Griffiths that says that when you do caveat, it is notice to all the world. But when Just's case came before the court in 1971, so we've had a bit of an elapse of time here, haven't we, between Abigail and Lapin and also Butler and Fairclough earlier than Abigail and Lapin, so 1917, 1934, and now 1971. But in 1971, Chief Justice Barwick is saying that, well, that's if you caveat, I don't disagree, that's what it does. But if you don't caveat, that doesn't mean that the prior interest should be postponed merely because you haven't caveated or used the caveat provisions. Now, there's 2 points that I want to tease out from that. Firstly is, I want to take you to a comment made by in the more recent case of Garneau and Black, where there's some dispute between, on the one hand, Chief Justice Gleeson, this is a much more recent case, and the approach of Justice Callanan. And in that case, what actually transpired was that Callanan took quite a contradictory view and disagreed with the approach of Barwick and said, well, it's actually quite important to caveat, and I think it's not right to say that if you don't utilise the caveat provisions, then that doesn't have any effect. That he went back to Barwick's statement in Just's case about this idea of it being subversive to the system if you were to say that the caveat, if you don't caveat, then that's quite fatal to your interest. So what do you think about those different approaches to the caveating process in terms of protecting an unregistered interest or an equitable interest? Any thoughts?
Look, I think you're probably best.
Lisa?
I was just going to say you're probably better to err on the side of caution and caveat, even though, because there are a lot of differing opinions as to whether you should, but I think you'd be better off using a caveat to protect your interests.
Grant? No? Okay. You're not coming through, Grant. Maybe put a chat up if you want to. What you've suggested, Lisa, is a prudent approach, but what I'm asking is it required, or is it something that should be done? Is it something that is required to ensure that your interest, if you have an earlier interest, isn't postponed? That's the point, really, between Callanan's approach in Garneau and Barwick's approach in the Just case. If you're trying to speak, Grant, it's not coming through. Sorry, there must be maybe a problem. Not getting any sound. I can see you put up a couple of chats, but yeah. Anyone else on this point? I mean, Lisa's indicated what's prudent, fair enough, but I want to press the point a bit further. Is it required? Should it be required? And if you don't, should you then run the risk of losing your priority?
I agree with Lisa in that I believe it's a prudent course of action. However, as to whether it should be mandatory to do so, and if you don't, you lose your interest, I think that could be too restrictive. But then again, this is where a bit of a circular argument comes in. If you have people who are not, oh, hello.
Did you see that? Did you? Sorry.
Yeah.
That's my son. That's right. Go on. Yep.
No, that's all right. I'm just thinking that if you have people who are perhaps too trusting or who aren't given the correct information as to whether they should do so or not, then that can result in problems as well. So I don't know. I can't really answer it. I just reckon what Lisa said as to being prudent, I think that's a good idea. But mandatory, I don't know.
See, this is the Lisa here.
I was just going to say that even though Just lodged a caveat, it didn't do him any good because the bank still had the priority over his interests.
That's true. That's true. And the caveat doesn't. All the caveat does is it prevents the registration of other interests, and it alerts people searching the register of that interest, which is the caveatable interest, as the basis for lodging the caveat, which the interest holder has. So that's all that the caveat can actually do. All right, but this issue about the extent to which it can be or is required, this is something that there's been a bit of toing and froing, really, with regard to that between the different decisions of the court over time as to whether or not we need to see the caveating process as imperative or as just another thing that can be done as part of the process of trying to protect your interest. There's no issue with regard to the prudence of caveating, but for a considerable period, the view of Barwick held sway, but then we have this position or this view of Callanan, who seems to take an alternative position more in more recent times through the Garneau case, but not universally, because Chief Justice Gleeson in Garneau, of course, continued to support the view of Barwick from Just. So Callanan is by no means, championing a different path for the entire court here. And of course, Callanan has now left the court, as has Gleeson. But it is just this interesting jousting, if you like, of opinion in terms of the role of the caveat, okay? And it's just something to bear in mind. The other thing that is also important in this context is to understand the nature of the provisions under the LTA with regard to caveating, and also to understand the different timeframes for how long the caveat is effective under the LTA, and also under the circumstances under which the caveat will lapse. Several of the cases that you're looking at are not actually, as we've seen previously, not actually looking at situations that are proceeding from the provisions in Queensland under the LTA. So we ever need to be mindful of that when we're thinking about these questions and looking at these areas particularly we're considering case law that is coming from other jurisdictions and where the provisions are not exactly identical to those under the LTA. Okay, so coming back to problem 7, I mean, basically this question was to get you to explore the issue about, in the context of a competition of unregistered or equitable interests, the issue about postponing an earlier interest, and what do we focus on in terms of postponing the earlier interest? Well, we focus on the activity, the conduct, the behaviour of the early interest holder. We can look at the conduct and behaviour of others as well, but of that early interest holder in particular. And then the role of the caveat and how that should be perceived. I mean, the view of Barwick in Just is still a predominant view, but we do now have this voice being reflected, or this perspective being reflected, for example, through the judgment of Callanan in Garneau's case. And as the materials indicate, and as I think I indicate in my notes, that the role of the caveat is not absolutely finally decided in terms of protecting the earlier interest holder in this scenario. It is important, and I think I agree with Lisa, and I actually said this, I think, in response to her question posted on Moodle, that for matters from a practical and a pragmatic perspective, one would advise one's client to caveat where appropriate and utilise those provisions. But of course, as we know, clients are not always necessarily prudent, even with the advice of learned legal practitioners. So there we go. All right, let's proceed on, and let's have a look at problem question. Now, it's really important, of course, to appreciate we need to, on the one hand, understand some of the more demanding theoretical issues, and secondly, we need to also be able to apply that through problem situation. So who'd like to have a bit of a go at problem 8? And you can just start by just spotting the key bits of it, if you like.
Well, one issue here would be, sorry, can you hear me?
Yeah, I can, yeah.
Yeah, sorry. One issue here would be the bank, the loans officer not registering the mortgage. So that would be one issue.
So just before we get to that, Lisa, that's right. But can you just walk me through the factual, situation? What's going on here in the facts? Walk through. Can you do that?
Yeah, it's Aisha. Yes, I can.
Aisha. Sorry, yeah, Aisha. Yep.
So you've got several parties here. There could be possible mortgage fraud, or anyway, exceptions to indefeasibility. And
no, sorry, what I want you to do is I just want you to walk me through the factual matrix of what's going on. We'll get to the issues shortly, but just what are the just give me the factual matrix, who are the parties, what's happening, how are they linked to each other, and so forth.
Oh, okay, all right. Well, Bobbin is the RP.
Right.
His property is a lot under the LTA, so it'll be a Torrens title property, and then he has borrowed money from a bank, and he has mortgaged his land as security for that loan. However, as I said, the loans officer has not registered that mortgage.
All right, just stop you there. So B, let's use some initials here. We don't, B is the RP of the lot.
Yes.
What else is what other relationship? What other legal relationship has B entered into?
Well, I don't know. Do you mean like a loan?
Well, what B has a legal relationship with Nessie Bank, with N, right? So B is not only the RP, the registered proprietor or the owner of the lot, but what's the relationship with N?
Oh, he's a mortgagee.
B is not a mortgagee, no.
No mortgagor.
Right. So B is both the RP and now, pursuant to having entered into a mortgage with N to secure a loan, B is also a mortgagor. Yeah. Now,
Yes.
you can't, unfortunately, in these scenarios, we can't get away from things like, for instance, mortgages. We haven't done mortgages yet, and conventionally, you don't do mortgages early in a land law course. I mean, mortgages even came up in some scenarios in the foundations course, LAWS12066. We can't get away from these type of situations because the loan scenario and the security interest which underpins the loan scenario is the classic in terms of transaction, funding, issues, problems, sometimes fraud, forgeries, shenanigans, whatever, okay? But we don't, the problem is we don't fully know yet, fully, comprehensively, what does it mean to have a Torrens title mortgage, okay? And so I just say this, that...
It means that the mortgagor, oh shit, I can't remember. I always get mixed up with those two. The mortgagee.
Just be careful, Aisha. Just be careful of the language.
It means that the bank has a charge over the land if it's registered. Depends on the type of mortgage. If it's a traditional or an all monies one.
Just wait. Sorry, just wait. I'm not wanting to go down that track too much at the minute, right? I'm just wanting to clarify the relationships and the significance of that. So Bobbin, or B, is an RP, which means that B is the registered owner of the land under the Land Title Act, okay? And has assumedly indefeasibility of title pursuant to being the RP, okay? And then B enters into a loan transaction assumedly with Nessie Bank, with N, and that's secured by a mortgage. Now, that security and that mortgage then means that there is a relationship between B and N of mortgagor and mortgagee, where B is the mortgagor and N is the mortgagee. Now, under the Land Title Act and under the Torrens system, for a Torrens mortgage, and in Queensland that's all mortgages under all land mortgages touching land. You can have mortgages touching personal property as well, but mortgages touching land. The RP, or the mortgagor, remains the owner of the land. Now, that's important because all that the mortgagee acquires is a security interest in the property, okay? And we'll learn more about this when we study mortgages, Torrens mortgages, a bit more comprehensively in a few weeks' time. But I'm just emphasising that because the other type of land, general law land, which doesn't exist in Queensland but predates the Torrens system, the arrangement was quite different. And in some of the earlier cases, sometimes that's adverted to. And when I say it's quite different because what actually happened under general law, that's non-Torrens scenarios, is that the owner of the land had to convey their title to the mortgagee under general law land. And then over time, equity recognised their right to have the property or the property or the lot reconveyed back to them at the end. But to get the loan and for the proposed mortgagee to take the security, they actually ended up acquiring the interest in the property as part of the process. Now, that doesn't happen in Torrens, and it doesn't happen in Queensland today because all land is Torrens in Queensland. But that's historical, but just need to appreciate that in this case, Bobbin, RP, even though the property is mortgaged, continues to be the legal owner of the land and the registered proprietor of the land, and therefore can do things with respect to the land, but often a requirement under the mortgage to advise the mortgagee of when they want to do things, for example, sell the property or whatever. Okay, so I just wanted to point that out. All right, so Aisha, do you want to continue with the fact scenario? So we've got Bobbin as RP, Bobbin as mortgagor, Nessie as mortgagee. Just tell me a bit more about the facts.
Yes, okay. So instead of B handing the CT over to the bank, he retains it. And just with regard to that, the bank didn't request it, so they, just as an aside, may not have fulfilled section 11A and 11B. And then B needs some more money, so he approaches his friend.
Can I just stop you there? Stop you there. So another, you're going well, by the way. Got to get used to my interruptions though. The other point I just want to comment on along the way is, again, in Queensland, see, this issue about the certificate of title, again, rears its head up. So that in many of the cases that we're looking at, there are issues about who has the certificate of title, or who has the duplicate certificate of title, or have you been sufficiently careful or prudent with the CT or the duplicate CT, or have you been careless with it, or has it accompanied the transfer, or it hasn't accompanied the transfer? In Queensland today, in 2014, certificates of title, they don't actually, when I was at the Queensland Land Registry last month, when I was up there for that conference, and I went and visited them beforehand, and they've kindly given me a slide presentation which I put onto the course website, and please have a look at that. I put under the welcome message page from the Land Registry office, and just have a look at that slide presentation. I think it's quite informative. But they actually don't even refer to these documents any longer as certificates of title. They actually call the document an indefeasible title, because you must remember, under the LTA, indefeasibility is part of the language of the legislation, which it isn't in many other jurisdictions within Australia. Right? That's the first point. So they don't necessarily talk about certificates of title. I mean, there is still a nomenclature using that phrase, but the land title, the land registry people themselves are tending increasingly to talk about indefeasible titles. Now, the next point, which becomes a bit more important, is that a certificate of title or an indefeasible title actually doesn't issue any longer as a matter of course in Queensland, because we now operate within an electronic space. Okay, and as I've incorporated that into the scenario, we haven't quite got there yet, but I've incorporated that, right? The idea of this electronic context in which things happen today. So again, this body of case law dealing with who has the CT, who doesn't have the CT, how careful you've been with it, or with a duplicate CT. We have to be just a bit careful in how we're using that body of law today in Queensland, where CTs no longer actually issue as a matter of course. However, there's always a however in law, isn't there? Qualification. The however is that the mortgagee can request one. And of course, in this scenario, we actually have a mortgagee involved. So just want to say that and make that clear and plain. Aisha, please continue. Doing well, doing very well.
Okay. All right. So B wants to borrow some more money, approaches the friend. The friend does a title search, and he didn't find any other registered interests because the bank had neglected to register its interest.
So if Van Jersey has done a search, because he's a very clever law student, right, and he hasn't discovered anything, so there's no other interests there noted on the actual indefeasible title itself in electronic form, and what else, if there's nothing else there, what else does that mean? Not only no interest, but what else from what we've just been discussing in the previous question?
Are you asking whether B would have fee simple and indefeasible title?
No,
and also whether there'd be-
not going down that path. I'll just put you on hold for a sec, Aisha.
Okay.
Just put you on hold for a sec, Aisha. Anyone else want to come in at this point? What other, if so, Van Jersey's done a search of the title, all right, on the electronic database. No interests revealed. Nothing else is revealed. So not only no interests, if nothing else is revealed, what else does that say hasn't happened?
That the mortgage hasn't been registered.
Yes, that's what we mean by no other interests recorded. Yes, but what else? What else could have been could have happened, and it would flag something on the system? We've just been discussing it with regard to question 7.
The caveat over the property.
Yes, very good, Luke. Thank you. So the search reveals nothing. So if it reveals nothing and no interests, that means there's no other registered interests. But if there's no, it would also reveal if a caveat had been lodged, all right? So if nothing is revealed, that means no caveats have been lodged. But as we've already seen, the lodging of a caveat is not necessarily determinative. So just because no caveat has been lodged and therefore not tossed up on a search doesn't mean that there might not be interest there. Okay, so back to you, Aisha. Okay, so just clarifying that. Keep taking us through the scenario.
Okay. So, yeah, as you've said, there's no registered interests. So the money is advanced to B, and the clever law student gets B to complete a mortgage document, and he stores that. And then B gets into further financial difficulty, and he can't pay the bank loan or his friend, et cetera, et cetera.
Right.
And then there's been a slump in the property market.
Right.
So
So
what would you like me
what
to do?
is this question really addressing in terms of, what are the things that we have to resolve here?
Competing interests?
Is that you, Aisha?
Yes,
Yeah.
competing interests.
Yeah. What sort of competing interests?
Unregistered.
Unregistered. Right. Unregistered interests.
Unregistered.
Okay.
Yeah.
And if we've got a competition between unregistered interests, what's the normal rule?
The first in time.
First in time.
Rice.
Okay. Rice and rice. Exactly. Okay. But first in time can be displaced dependent on what? What is the next thing we need to think about?
Whether those interests are equal or the equity is equal.
Right. So whether the interests are equal. Let's have a look at the interests. Are they equivalent interests?
Yes, both are mortgages.
Both equitable interests, one prior and one subsequent.
Right. Is there anything that differentiates the interests in any way, or they're exactly equivalent, would you say?
The conduct of the prior equitable interests in failing to lodge.
No. Before we get to the conduct of the parties, I'm just looking at the interests themselves. So we're saying we've got unregistered interests here. We're saying the interests are equitable. Are they apart from the time issue and not the conduct issue? We'll get to that shortly. Is there anything that differentiates the interests before we get to the conduct issue?
Yes, I'd say that the mortgage over the property versus a personal loan, I suppose.
How I need more from you, Luke. A bit more. We're trying to work out, is there anything different in terms of the mortgage to Nessie Bank as opposed to the mortgage to Van Jersey? Does it make a difference that one's a bank and one isn't? Necessarily?
Doesn't it come back to just the timing then?
Don't worry about the timing at the minute. I'm just asking, are the interests equivalent? So does it make a difference what the entity or the status of the mortgagee is? Does that make a difference?
I have no idea.
I wouldn't think it would, Michael.
No, not necessarily. Why should it? Okay. Just because it is common ground today that the predominance of mortgages are offered by financial providers and sometimes large multinational financial providers, that doesn't mean that the security interest over an interest in land, because of the status of the mortgagee, is any different to a security interest that an individual might take over an interest in land. Okay. Historically, the case law is often looking at scenarios involving mortgages underpinning loans made by individuals. In Abigail and Lapin, for example, we're talking about, loans made by individuals, not by large financial organisations. We're in a different historical epoch, but what we're concerned with here is the instrument, the land law instrument, not the status or the size of the entity or the party. Right? So you need to be careful about that, just scrutinise that. Is there anything different in the facts explaining the instrument or the actual mortgage itself between the two situations that's in any way different between, that is, the mortgage between Bobbin and Nessie Bank and Bobbin and Van Jersey? Just in the factual information, anything different?
From what I can see, with the bank, he's actually mortgaged his land as security for the loan, whereas if I'm looking at the loan from his friend, it doesn't talk about land. But then they're both holding a mortgage document. So doesn't it depend on whoever registers first will displace the other, because they're both holding a mortgage document?
But they haven't done that, have they? Okay, so we can't get to registration because neither has registered. Okay, so we've got two unregistered interests. So the provisions of the Torrens Act don't help us in terms of priority with respect to unregistered interests in terms of the registration process, because there is no registration here. And it doesn't help us to say they should register or rather, whatever. But one thing we can do is we can differentiate between an interest that's unregistered but registrable and an interest that's unregistered but not necessarily in that situation of being able to be registrable. What do I mean by something that's registrable, do you think?
And an interest that can be registered, such as property and mortgages and things like that. So perhaps something like a chosen action card?
Can be, yes, that's right. But also it's about process, so that for something to be registrable means that everything has been done that needs to be done to put it into a situation where basically the last step of registration is all that's necessary. Don't forget that we can have interests that are not ever going to be in that situation of being able to be registered under the system. And we can have other interests that may well be able to be registered but just haven't been registered. And the law does differentiate between interests that are registrable and interests that will never be able to be registered. And we can only determine that based on the facts and the information. So we do appear to have mortgages here that are quite equivalent. We certainly, you'd expect with regard to the bank that, the documentation had been completed, and it certainly appears that all the documentation has been completed, just hasn't been registered. With a private individual, sometimes those processes are less formal and less structured, but you notice that the facts have deliberately made note of the fact that there is a mortgage document which has been completed. So if that hadn't been there, that phrase hadn't been there, then you might ask, well, do we actually have anything here? Is there any document in place? Because with individuals, sometimes things can be a little bit less formal, and then we might have something that differentiates. But arguably, we certainly seem to have interests that are largely equivalent here, and the fact that one is with a bank and one is with an individual doesn't mean that they're not equivalent. I think that's a fair way to analyse the facts. But we do need to scrutinise the factual information carefully. Right? So if we get to that point that we've got unregistered interests and they seem to be largely equivalent unregistered interests in the nature of mortgages, we know the general way to deal with that is first in time under Rice and Rice. But what do we then examine to displace the Rice and Rice approach?
Conduct of the earlier party.
Conduct. Yes, thank you, Luke. And can you talk us through that a little bit and maybe take us to a case that might be helpful in that sense?
Abigail?
Well, before we get to the case, can you just take me back to the facts in terms of the conduct of the earlier party? So who are we looking at?
We're looking at the bank.
Right, Nessie Bank. Now, here is another dimension, right? When you're looking at an organisation as opposed to an individual, and you're talking about examining conduct, what are you then scrutinising?
Things
the
like
process again.
Sorry.
Process, but an organisation has to work through people, doesn't it? It has to work through its employees, its staff. Whereas an individual like Van Jersey, that's him, unless he appoints someone else as his agent to act on his behalf, which is possible. But on the facts, no. He's just up doing his own thing and he's having a direct relationship with his friend, a business transaction with his friend. So if it was Van Jersey, you'd be examining Van Jersey's behaviour and conduct. But in the context of the bank, you then have to say, well, all right, wait a minute. We've got a large organisation here. So in considering the conduct of the bank, whose conduct then do we actually examine? And there's been some debate about, well, can you look, for example, at different people in the organisation and link them together and say, well, if we build, the sort of things they've done and we accumulate the actions or the behaviour of these people, we can maybe mount an argument to say that there's a sufficient amount of behaviour and conduct there which meets a standard that will postpone their interest. What do you think about that? I mean, on the facts, what are we, what behaviour are we examining of who, and whose behaviour should we be examining, do you think?
Michael, wouldn't the bank be vicariously responsible for the conduct of its loans officer?
It would, assuming the loans officer is an employee of the organisation, and again, you know, we have to put ourselves in the modern period. No information on the facts here, but again, in the modern period, as you know, in organisations, there's a lot of contracting out of various services to try and build in efficiencies within organisations. So, but if the loans officer is an employee, then yes. But where does a loans officer sit in the organisational structure?
Probably fairly low down, but that would depend on how much he's authorised to lend.
Yes, but why didn't? What was it that caused the non-registration of Nessie's mortgage?
The restructure and the office relocation.
Ah, and is that the responsibility of the loans officer?
Probably not.
Ah, that's right. Probably not. So, the plot thickens, people, as ever. There's a bit of I've twisted it around deliberately like this because I want to get you to think about what it is you need to be examining, okay? Whose behaviour, whose conduct in the context of an organisation, for instance. It's all very well to say, yes, we need to, you know, the case law explains that it's the conduct that we need to be examining. But unfortunately, much of the earlier case law is examining the conduct of an individual who was the mortgagee, for instance, all right? Or the various interest holder that the unregistered interest holder that they're examining, very often a mortgagee, but not always. But in modern life, where organisations are the predominant providers of finance and so on and so forth, the situation becomes more complex. In fact, there's even been some case law to suggest that you can't, what I was suggesting before, is you can't actually accumulate bits and pieces of behaviour and bring it together and say, oh, right, just sticky tape it together, and therefore that's the behaviour of the organisation. The other issue that arises too is questions about internal responsibility and who has responsibility for what, and that could at times toss up ideas of agency and so on, and what sort of individuals in the organisation do we need to be concerned about. What would be your general, in light of the case law about, so once we get over the issue of whose actual behaviour and conduct we need to be scrutinising for the purposes of this issue of the conduct possibly postponing the interest of the unregistered interest holder, what's your, looking at the case law in terms of how it's examined conduct and behaviour, what would you say about the bank's conduct and behaviour in this situation?
Well, I don't think there's anything on the facts that make the registration or the emission look malicious or unreasonable. So I think it could have just been a simple forgetting to lodge the mortgage. So I think when you're looking at conduct,
is it just forgetting? Is it just that? What else is being suggested by the facts?
Oh, well, it's the facts are suggesting that due to the restructure and the office being relocated, the poor loans officer was so stressed out that they forgot to lodge the mortgage.
And what is that suggesting about the organisation?
Oh, that they're overworked, underpaid and overstressed.
Well, about the loans officer, but what does it suggest about the organisation if this can happen?
That the training or something may not be up to par.
Yeah. Is anyone else think that's good on the right track, Aisha? Luke?
Lack of process or lack of structure in their dealings with the mortgage.
What's the
and registration.
what's the test or the standard I'm trying to reach out towards? What has the courts said is what they're concerned about with regard to justifying postponement? I mean, one of you indicated earlier, it might have been Aisha, I'm not sure, that said, well, you know, there's nothing there that's really untoward or fraudulent or whatever. Well, of course, I mean, I don't think in any way one can be suggesting that there's fraud going on here, certainly for the purposes of fraud under the Torrens Act or even equitable fraud. I don't think that's being even suggested. But the point is that what is that which is required to postpone? Or is it something less than that? And the less, what is the less that could be conceivably justifiable to postpone?
Doesn't it come down to looking at whether the conduct is just unreasonable?
That's not bad. I'm thinking of a C word.
Oh. Right.
Something less than fraud.
Oh, unconscionable.
Oh, that's a U word. That's a U word.
Getting there though, it's almost a C word.
You are, and that's a good response. I don't think you can. I mean, unconscionable, suggesting something unconscientious, suggesting a deliberate exploitative, taking advantage of vulnerability. I don't think that's going on here. In truth,
looking at these facts, though, the loans officer not only forgot to lodge the mortgage, but he was also careless in that he never requested the certificate of title either. So he'd been careless twice.
Ah, here we go. A point that had been passed by up until now. Well spotted. So, and therefore, can I come back to my C word? What is it? I'm sure it's on the tip.
Careless.
Ah, there's the word, the magic word. Magic word. Right. So, careless. Now, the question here is, this question actually has a couple of layers, as per usual. Is carelessness sufficient to justify postponement? One. And is it just the loans officer that we're looking at? And in the context of an organisation, we possibly have to ask other questions about if this is happening when an organisation restructures and relocates, then doesn't it suggest that there's been a lack of due process and structure with regard to how they look after important documents and these sorts of things? And that's one thing. And the other issue is it just the loans officer that's responsible here, or is this a bigger, trail of carelessness? And does that necessarily justify postponement? That's the critical point at the end of the day, because otherwise Rice and Rice will govern two equivalent unregistered interests, and the bank's interest will continue as first in time to take priority over Van Jersey's interest, even though Van Jersey has done the searches, nothing's revealed, and so forth, right? So that's the question that has to be faced at the end of the day. And what do you think? We're almost on time, people, but what do you think?
No, I don't think that that this conduct would lead to postponement. And I would look at other cases. I know we'll get to it at some point, like Gurgic, where the practice points to carelessness, not willful blindness, and could be a less than meticulous practice.
Ah, that's nice. That's nice. But, I think that's right at the end, in the final summing up. But, the judges at times come up with what I might otherwise call, I'm not trying to be disparaging at all, of judicial brethren, but the idea of willful blindness and carelessness, and that clearly one is not good enough, but the other is. But people in the cut and thrust of business life and organisational life, and the stresses and the tensions that exist, as indicated, and which this poor loans officer may well be in the midst of, the slippage between what necessarily constitutes that more grave characterisation of behaviour, willful blindness, for example, for want of a better way of expressing it, and mere, and I just put in quotation marks, mere carelessness, the slippage between these is not always clear. Your task, of course, at the end of the day, in thinking about this type of a question, if not in reality, at the end of the day, when you're done and dusted with got your degree and you're out there working with clients, is there is not necessarily just one answer here, but it's a question of how you're using the law to navigate your way forward, and what is best in all the circumstances given the totality of facts. That's often the best that can be pitched forward, okay? But there may be countervailing positions, and it may not be clear cut, as it often is not, all right? And what is best advised in terms of what should be the predominant interest at the end of the day, and then also draw back and say, look, looking at this picture, looking at the types of interests that are in competition, looking at the behaviour and the conduct, what should be the outcome in terms of what's reasonable, but in terms of what is the just and legitimate basis of resolving this matter, because that's what the court has to do. And in a sense, that's what you're simulating in your attempt to resolve these problems in this way. In reality, in practice, you'll be acting for one side or the other. You'll be acting for De Jersey, you'll be acting for Nessie Bank, you'll be acting for Bobbin, and they'll want you to go in hard for them because you're representing their interest. But they will also, even though they may not always identify it, they will need you as their professional advisor, you as their professional advisor. They will need you to be able to anticipate the argument that can come from the other side that may knock down your argument or weaken the strength of your argument. And that's ever how it has been in terms of law and law practice, and trying to work out and sort our way through some of these puzzles. So I think at the end of the day, with regard to problem 8, that the bank's interest will not be postponed because there's not enough there to justify postponement, unfortunately, for Van Jersey. And both should have been more prudent in the way that they decided to proceed with regard to their mortgageable interests under the LTA as mortgagees. All right, so there we are, people. Unregistered interests and priorities under the Land Title Act, the Torrens legislation. What I might ask you to do is just in the normal way, just take a sheet of paper and jot down 3 takeaway points. What are 3 takeaway points that you want to take away from today's class? And then just very, very briefly get you to share maybe one of those before we close.
Well, one of mine is the who is first in time, and then working out the different aspects to what could affect their interest, such as one here that we've discussed, which is conduct.
Good. Thank you, Aisha. Thank you for that. Indeed, as ever, Lisa, as ever. Luke, any thoughts?
Just probably the process with regard to first in time displacing the interests, conduct, and move on from there.
Yep. Grant, are you still with us, Grant? Grant might have left us. Yep. Look, all right, that's fine. That's fine. And the other thing that I just want to leave you with is that today, of course, all of this is taking place within the context of electronic transactions. Okay, and we need to keep reminding ourselves about that. We do in our general, operational space, of course, but in regard to thinking about these issues and these challenges, we have to update the nature of how we understand these issues and conflicts in that situation. So that in this case, for example, we would actually be talking about documentation in Nesibank being saved on their computer systems. So if we can't find it on the computer systems, does that mean that there's been a problem with their computer systems, or that they've done something that's caused a corrupting of the systems? If that's happened, actually, then that actually may be viewed more seriously than just misplaced boxes. Right? And don't forget also that with electronic titling and electronic conveyancing, everything is occurring with, and increasingly, not fully realised yet, but increasingly within that e-space. So it's not about people holding a document, a CT, or people not doing something with a duplicate CT, or a bit of paper, but it's the document being on an electronic system or not being sent electronically to someone else. And as I mentioned to you in a previous class, the Lands Registry in Queensland doesn't even take original documents anymore. What it takes is scanned in versions and then destroys the original document, if it even gets it. So it never actually even sees the original document. But speaking to Land Registry personnel, very interesting that, guess what, surprise, surprise, when there's a dispute that goes before the courts in Queensland, even in 2014, what does the court require? But the court requires a certified copy of the document, which then has to be produced by the registry and certified, even though they don't keep a hard copy. But the court still needs a certified copy for legal proceedings. So again, it's an indication that unfortunately the judiciary are not quite as up to speed on the electronic space as public agencies, and indeed as we are in terms of how we're functioning. So that's just something to bear in mind and to be constantly borne in mind as we progress through the balance of these topics in land law. There we are, people. Thanks for joining today. We will soldier on next week with topic 5. Bye for now.
Thanks, Michael.
Great. Bye, Michael. Thank you.
Bye.